Well, good afternoon, everybody. This is Lucian Pera in the Memphis office of Adams and Reese, and Caitlin Amick is with me here from the Atlanta office, and we're here today to talk to you about lawyer cybersecurity. This is one in a continuing series of internal CLEs we're doing, where we have invited a bunch of clients and friends to join us, and as a result, be aware that as we go through, Caitlin and I will probably both have some comments directed more at our internal people, and maybe a few also directed at folks outside the firm. But since your needs and situations are a little different, and we know our colleagues' needs and situations pretty well, I think, between the two of us. With that, and one other thing before we get going, and that's questions. You will see a box on your screen, as I understand it, that says questions. And remarkably enough, that is where you put questions. So put them in text and hit the little send button. I think, as I understand it, you will be able to see each other's questions, and we will try to get to them as we go through, and maybe at the end we'll clean up a little bit, but we'll do the best we can. And don't be offended if we don't answer every question. We'll do the best we can. So, lawyer cybersecurity. In the last few years, I have either presented or been to more cybersecurity programs than any human should have to either present or attend. And, you know, they all are kind of the same. And that's why about a year and a half ago, I started trying to formulate something a little different. And Caitlin has improved it, so hopefully it'll be good. But they all start the same way. They start with scary stuff. So like on your screen, these are old, but whatever. It's just to remind you, that's how most cybersecurity programs start. They scare you as much as they possibly can. We do not intend to do that today. We intend instead to try to be practical and useful and helpful in trying to get you to a place where you can get a little bit safer every day. But before we get to exactly our agenda, let us introduce ourselves. I'm Lucian Pera from the Memphis office. I'm a partner in the firm. I do, as many of you who are members of the firm, part of the firm know, I do some legal ethics work and media law and commercial litigation, and the ethics piece is where this arises out. I'm also Jeff Richardson's poor predecessor as chair of our technology committee, but nevertheless, those are my quote credentials. But now, Caitlin, tell everybody about yourself, because everybody may not know your background.
Sure. Hi, everyone. My name is Caitlin Amick. I'm a paralegal in the Atlanta office of Adams and Reese, and I work closely with the privacy, cybersecurity, and data management team. And I'm also a certified information privacy professional, which is given out by the International Association of Privacy Professionals, which is a mouthful. But it's a process where I take tests about US and European Union data privacy laws, and there's continuing education requirements kind of similar to a CLE. So I've held that certification for a little over a year now for both US and EU law, and that helps when I'm working with the privacy team doing vendor contact reviews, data breach responses, and a variety of other practical matters when it comes to privacy and data management.
So you have an ethics nerd and a real expert on the line here today. So the IAPP is they're a serious organization. So we're thrilled to have Caitlin as part of the firm, but also today to be with me and have the benefit of her knowledge. So let's talk about our agenda. All right. So here's the premise of today's program. Years ago, I've been kind of a techie sort of person, for a lawyer. For a while, and one of my probably two favorite technology columnists was Walter Mossberg from the Wall Street Journal, who did a wonderful, I think it was weekly, column for years and years. And the first column he ever wrote started this way. You see it on your screen. Personal computers are just too hard to use, and it isn't your fault. He was an advocate for consumers, and he started by telling everybody that technology was really hard and it wasn't the user's fault. So today's approach is similar in the sense that we stand for the proposition here that lawyer cybersecurity is scary. It isn't our fault, okay? And it doesn't have to be scary, and we can each tomorrow be safer than we are today. How? Well, we're going to learn a few things today. We're going to also commit to learning a little bit about tech, a little bit at a time, continuously. So let's move on here just a minute. And here's what we're going to actually talk about today. Actually, the actual agenda is, first, we're going to do a little review of ethics, about our ethics obligations, and 3 ethics opinions that I think are the key ethics opinions that give you pretty much everything you need to know as a basis for figuring out how lawyer cybersecurity ought to work. Then we're going to have a sort of buffet of things that you need to know that might practically improve your life in terms of lawyer cybersecurity. Dangers, tools to fix them. And by the way, on the PDF that I believe we're going to circulate afterwards, the notes will have some resources to get you to some answers on those. Now, on the resources, a couple of things. One, I'm sorry, I'm jumping ahead of myself here. So the goal then, let me restate the goal I already talked about. It's going to be not to necessarily be perfectly safe, because I'm not sure that's possible. But it's also not to merely meet your ethics obligations, because as you'll see in a minute, nobody wants to stop there. We want to do better than that. But it is, in fact, to be safer tomorrow from all these dangers that we're going to talk about than we are today, and then to continue to do a little better than that each day over time. So now to resources. First is your new best friend. If he or she is not already your best friend, your tech guru, about which more in a few minutes. Also, here's a book. I'm a big book person, and you can get it electronically. I don't have to cut down a tree. But this book is actually a really nice, annually updated survey of practical technology that lawyers actually use at a granular level, in English, occasionally funny, by a couple of the smartest people on lawyer legal tech. Not very expensive. Actually, I own it. It helps me. If you're getting a new computer, for example, they have very specific practical recommendations. In any event, I recommend it. All right, so let's start. Number one on our hit parade. Oh, again, I'm trying to get ahead of myself here. Sorry, I'm trying to skip things. Well, what is now on your screen is one other reason we all need to be aware of this subject, and that is clients actually are paying attention. Now, we're going to talk about clients paying attention and sending us 40-page technical guidelines for what we can do on cybersecurity, but they're also paying attention at a very practical level. This list of questions is questions that Inc. magazine told its readers they needed to be asking their lawyers. So look at some of these questions. These are very practical questions. I'd be willing to bet a lot of us have gotten these questions. So clients are watching, and clients do care about cybersecurity. All right, so now let's take a look at your ethical obligations. So here are the sources, all right? There are, of course, the ethics rules, all right? We're going to talk about those for a minute. There is the standard of care for which lawyers are answerable in tort, lawsuits, malpractice suits, and such. In addition to malpractice, many of you know that one of the favorite tools of plaintiffs' lawyers in bringing claims against lawyers is not just malpractice claims, but also fiduciary duty breach claims. And I don't think there's any question that lawyers are going to be found, as the cases evolve, to have a fiduciary duty to their clients to protect their confidential information. There's also contract, though. I mentioned a minute ago outside counsel guidelines, technology requirements imposed on us by our clients, and those effectively are contracts, right? If we don't do those and something bad happens, you can bet that there will be an additional count for breach of contract. And then there's other law. Some of this other law is directly in the area of Caitlin's expertise and her team's, the privacy team's expertise, HIPAA and data breach notification laws, and all kinds of other laws that affect data privacy. We're not going to talk about all that, but we are instead going to start with the ethics rules. So here are the primary, and by the way, I'm hopeful that this will be the shortest ethics part of our presentation at the ethics piece that you'll ever hear about cybersecurity, because frankly, it's all you need to know as the foundation. So your ethical obligations, they start with two rules, 1.1 and 1.6. 1.1 is the rule on competence. And we know that rule. It's if you've heard of any lawyer discipline cases, you know that that's one lawyers often violate. But it's specifically back in 2012, the ABA added to the model rules, and it's now a part of the rules in 39 states, okay, as of last week when California picked it up. This language is in the comment, defining what competence is, and it added the underlying language. So it said that to maintain the requisite knowledge and skill, which is required by the rule, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. You got to know, you got to be competent in using the technology that you actually use as a lawyer.
Okay, Lucian, I understand that the ethical obligation is to be competent in technology, but what does that mean in real life? Do the attorneys need to figure out how encryption works or how VPN operates? Do they need to look up and figure out the difference between 4G and 5G cell service? What do they actually what are they actually required to be competent in?
Only if you're Jeff Richardson do you need to know those things. But other than Jeff, no. For those not with the firm, Jeff is our technology chair, and I say this in the most loving way, a geek, a tech geek. He's great. But the answer is no, I think. So do you need to, and we'll talk about this as we go on, but do you need to know how encryption works or that it works and what you might use it for and what you need to use it for? My view is it's the latter. So for example, all of us as lawyers, very early on, were trained to issue spot, to recognize problems. So hopefully, if I get a real data privacy problem, the likes of which we need our data privacy team for, I will see it. I'll say, that's a problem I need to call Caitlin and David Katz and all these people about. But that's what I need to know. And then I need to get that expert help to help my clients, right? I think it's very similar. So that's why what we're talking about today, in my view, is we're trying to tell you what encryption is and when you might need to use it and what its purpose is. But I wouldn't begin to be able to explain, technically how it works down at the code level. So let's take a look at the next slide. And this is the other rule, is 1.6, the main rule on confidentiality. And this, for the first time again in 2012, put in the black letter of the rule what was already our obligation, which is to make reasonable efforts to prevent inadvertent or unauthorized disclosure of or unauthorized access to confidential information. The key words there are reasonable efforts. Now, also, key point here too, look at the comment. The comment says we are not going to be sanctioned as lawyers under these rules. These rules are disciplinary rules after all, but we will not be sanctioned if we do what the rule says and we exercise reasonable efforts and there's still something bad happens, an unauthorized access to or hacking or loss or whatever. Now, you should immediately realize, well, that's nice, but that doesn't mean the client's not going to sue you. It doesn't mean the bad thing is not going to have terrible effects, and which is why I started the hour by saying it's not enough. None of us are going to make our goal meeting our ethical obligations. That's the lowest threshold we have to cover, and we're going to do better than that. So that's the rule and what it says. Now, let's move on to just a couple more slides on the ethics piece, and then I think your ethics obligation for the hour will be met, and we'll go on talking about practical stuff. There are 3 ethics opinions from the ABA that are really good on this. They are sort of a trilogy, and they start with the most important one, 477R. Let's see. Hang on, I've got lost in my own slides here again. Yeah, here we go. I'm sorry. So 477R, this is one that essentially what I just talked about in terms of 1.1 and 1.6 explains that in a little more detail. And it takes factors, you'll see them listed there, that are some of which are listed in the comments to 1.6, and lays them out and then explains them a little bit, explores them a little bit. So instead of a phrase, it gives you a paragraph and some thinking about what matters. And you'll see the kind of factors that have to guide figuring out what reasonable efforts are. And they're sort of obvious. The sensitivity of the information, the likelihood of disclosure if additional safeguards are not employed, the cost of the safeguards, the difficulty of implementing them. And by the way, whether if you implement them, you'll never be able to deliver the services or use the technology to deliver the services for the client. So those are general factors. And that they then use that analysis to apply to, well, can you use a certain kind of technology? And if so, how? Which is the subject for the rest of the hour. The next of the 3 opinions is 483 from the ABA. This was a little later, I believe. And here, this is the one that is about our obligations concerning data breaches or cyber attacks. And so it says, among other things, that we have a duty to monitor for a data breach. We have to, if something bad happens, we have to determine what did happen. Was information, as Caitlin and her folks like to say, exfiltrated, which I love. That's a great term. Or was it stolen? Was it used, right? And we got a duty to respond and restore systems and maybe to notify clients. And by the way, remember, the opinion points out we got to remember not just what our ethics obligations are, but our obligations under other laws. So that's the second of the 3 opinions. And then the third of the 3 opinions is, you might not think at first blush that ethical obligations relating to disasters is related. Well, it sure is. And our firm, I think, is very cognizant of, very good about the planning needed to protect us against disasters. It's okay, you don't have to be in a hurricane, you don't have to be in a flood for it to have a dramatic, disastrous effect on your practice or on your life, right? The Nashville area had another series of devastating floods in the last week or so, for example. And what you see from these these obligations. And let's, well, I don't have a full list here, but you need to have a plan to respond to a disaster. And what you're going to find as soon as you think about that is that those obligations are often overlapping with your obligations to protect confidential information. So, for example, using the cloud is a great answer to that, because of course, the flood is not going to take out your servers if you're in Nashville and the servers are instead in Amazon Web Services or wherever they're going to be soon after we do what we're doing with respect to moving our data around. Anyway, so those are the ethical obligations mostly, but there's one more piece that Caitlin's going to add.
Yes, so tying into the duty of competence, it's very important for you to know what you don't know and to seek this help of a specialist when you think you might be getting in over your head in certain areas when it comes to data privacy. So we wanted to give you a high-level list of some scenarios where your spidey senses should be going off, and you should be thinking if you have the requisite knowledge to be able to address your client's needs in this situation, or if you need to reach out to a data privacy specialist. One of the biggest areas of concern is when you're negotiating a contract where a third party is going to be getting access to your client's data. This raises two different issues. The first is client confidentiality. So if the actual negotiations of that contract are going to require that third-party vendor to have access to data, you have to, under the ethical rules, get your clients informed consent to give that data over. The second is the actual terms of the contract that you negotiate that grants that third-party access to your client's data. These contracts on the surface might seem like your run-of-the-mill vendor contract, but there are some very specific terms you need to look at when data is being shared or sold to a third-party vendor. Some things you want to think about are, does the contract discuss what happens in the event of a data breach? Who's responsible for sending out the notifications that are required under law? Who's going to pay for that? What representations and warranties are made about how that third-party vendor is going to be protecting the data? What kind of permissions are you actually giving in the fine print for the data? Are they going to just be able to use the data to help your client? Do they have a permission to share it with sub-vendors? Share it with other people that might not be directly related to the contractual relationship? Do they have the ability to sell your client's data? You also want to look and see, does this contract potentially trigger the CCPA, which is the California Consumer Privacy Act? Or if you're dealing with consumers that live in Europe, you need to take into consideration whether the contract addresses the GDPR and other EU law. So we're not going into details about all of those laws. That's a whole other webinar, but just have that in mind if you're in a scenario where you're negotiating a contract where data is going to be given or turned over to a third party. Another huge scenario that your spidey senses should just go crazy if your client comes to you and tells you that there's been any kind of a data breach. And data breach can be huge. It can be a ransomware attack where it's super obvious, or it could be something smaller where your client is a medical provider and a receptionist accidentally sends one patient's medical information to the wrong person. It was an accident, but under certain laws, that's still considered a data breach or a security incident, and it will have certain reporting obligations. So if you come into that scenario, you need to be aware that the issue may get complicated really fast and have some specialists in mind if you need to reach out for help. Some other high-risk areas very quickly are on this slide. If you're helping a client, you realize they're collecting a ton of information, whether about their employees, their customers, if they're collecting data on children, there should be red flags going off for you. A lot of larger companies are now implementing fingerprint scans for timekeeping, facial scans, temperature scans, even in the age of COVID. These all raise potential questions. E-commerce is another huge thing that potentially triggers that CCPA and GDPR regulation that I mentioned earlier. And especially if you're helping a large international company that has a presence in Europe, and you know that data is going to be transferring from the European entity into the US, that's a red flag. And you should know that you don't know everything about that, because after the Schrems II opinion, which is a European Court of Justice opinion, no one can actually say they know everything about that because the state of the law is in such flux. So just be aware that these are issues, know what you don't know. And we like to say it's like if you're a real estate attorney, you know that you're not necessarily competent to try a felony murder trial. So it's the same type of thing. Know what you don't know when it comes to data privacy, and don't be afraid to ask for help if you need it.
Call Caitlin. Seriously.
Call the privacy team or reach out to one. And you can also reach out to your tech guru, which is the next slide, which for any of your cybersecurity issues, your tech guru should be your best friend. So what I want you all to do right now is get out your cell phone. I know you're probably looking at it anyway. And look in your contacts and see who would you call if it's 11 o'clock at night, you just went back to your car after getting drinks, and you realize your firm laptop's been stolen. I want you, if you have someone in your phone from your tech team that you would call to report this to, maybe send me a message in the questions link saying, yeah, I got someone.
See, if we were in person, we could offer prizes for this, but
yeah.
I've got on my favorites, I've got the help desk right here.
Right. So far, no one's said anything, so I hope people are just being shy. But you really need to have a legal technology expert, and you need to be really good friends with them. You need to feel comfortable talking to them in the case of an emergency. You need to be comfortable talking to them when you have routine questions. Why isn't my email syncing? Why can't I access our data file system? And so it's really important. I have our Adams and Reese has the after hours hotline. I would suggest that everyone at Adams and Reese has that in their phone. And then also, if you're at Adams and Reese or wherever you are, find the name of someone in particular and introduce yourself to them, develop a relationship with them, and if they're willing to give it out, get their cell phone. Here's a list of our technology team at Adams and Reese. And so these are the people that you should have someone on here that you feel comfortable reaching out to. And worst case, just have the help desk phone number in your phone as well.
And I see we have gotten started to get some answers. So, all right, well, let me move us on then to our next general category. Patch and update your software promptly and consistently. Now, for folks with the firm, this is generally done for you on firm systems, right? There's very little that we leave to individual users. That said, most of us have our own devices. You should install patches and update it regularly. True for iPhones and Android phones. And why is that? Well, because a large proportion of hacks, of vulnerabilities, of intrusions into data that have been reported come from the ability of bad guys to realize there's a vulnerability in the system and to attack through that vulnerability before the user installs the patch. You got to patch regularly, consistently. My view about this is real simple. Once you decide to use a new piece of software, and particularly this is for firm folks, it's about non-firm software, because we all use some non-firm software in some way, shape, or fashion for personal or other reasons, right? All right, if you're going to use it, before you use it, you want to make sure that it is safe to use and appropriate. And there's no problem asking any of our tech people when you get a new iPhone, right, or a new Android, it's got this feature on it. Should I use that? That's a perfectly legitimate question for your tech guru, right? All right, and if the software, the app, is something you should be using, then you should be willing to trust it to update itself appropriately. Set it to automatic and forget it. And by the way, don't use, and we do this as a firm, we have on a great campaign on this, don't use out-of-date software or devices. I guess it was last year, if I recall, I think early 2020, Windows 7 went end of life, which means no one out there, including Microsoft, will help you with any problems, okay? So there's nobody supporting it. Lawyers shouldn't be using out-of-date software, out-of-date devices.
One thing I just wanted to highlight here, I was looking at the list of the top 10 software that are vulnerable to hacks, and things that I don't necessarily think of were at the top of the list. Adobe, Skype, and Windows Media Player in terms of software, not just necessarily, we all know old Windows is not good to have on your computer, but things like that where you're tempted to just press the exit button when it prompts you to do the software update, it's really important that you patch those software as soon as possible.
All right. Go ahead. Sorry.
On a similar note, a lot of the software that you have is able to be tweaked in ways that can help improve your security. And if you're not comfortable knowing what type of security you need on your device or what areas can be improved on, this is a great area for you to consult your tech guru. Ask them questions about where you can improve your security, maybe on your cell phone or on your laptop at home if it's not a firm or company issued device. One great feature that Lucian was telling me about is Microsoft Office 365, the Secure Store, which is an app that will give you, it will evaluate the security of all your settings and give you a score. And the default isn't necessarily the most secure setting. Sometimes they charge additional fees to get a more secured setting. So if you're not sure if you need that or if it's justified, you know, run the Secure Score app, see what your score is, and then reach out to your tech guru and see if they agree that there are some areas to be improved upon.
And let me jump in to say, particularly to the non-firm folks, great product from what I understand, Microsoft Office 365. There's been a land rush to use it as everybody worked from home. And I'm certainly not suggesting it's at all insecure. In fact, I think it's very secure, but it's very, like with all things Microsoft, very, what's the word? You can tweak a million things on it. And you need to be careful to have some help tweaking some of those million things to get it as secure as you need it to be.
On a similar note, there's some things that you might be able to do on your own that aren't as intimidating. The first and foremost is have a good password on all of your devices. I haven't necessarily read a case that said the standard of care is that you have to have a, you know, an 8-character long password with lowercase and uppercase numbers or anything like that. But certainly having a password on your device is the bare minimum that you can do to protect yourself and the data that lives on your device. Another thing to look into is setting up Find My iPhone for iPhone folks, or on Android, there's the device manager, which is a similar thing. If your phone gets stolen or lost, you can be able to track it. And for laptops, Absolute's LoJack is one tool where you can remotely lock your laptop, delete files off your laptop, and find your laptop if it goes missing. So those are some tools, along with encryption, which we'll talk about in a second, routine backups, which we've also touched on, and thinking about if you should implement a VPN if you're doing a lot of maybe remote working or relying on a lot of Wi-Fi.
You should know where your data lives. There used to be a, this will show my age, when I was a child, there were at like 10 o'clock every evening before the local news, there was an announcement on a lot of stations that says, it's 10 p.m. Do you know where your children are? Well, I nothing against anyone's children, but frankly, it might be more important to know where your data is on any given day than where your children are. And here's all the places your data might be: your desktop, your personal iPad, your associate's iPad, your secretary's personal phone, your vendor's cloud. And what about the old flash drives that you have? Let's see, I have 3 on my desk here and probably another 2 or 3 in my drawers. That's probably not a good idea, I'm sorry to say. But you should know where your data is, because otherwise you don't know how to protect it. My favorite example is iPhones, where if you do what this fancy new iPhone says, you will likely, thinking you're doing a wonderful thing, send all your stuff to the iCloud, right, and back it up there. Now, I'm told our system will not let you move firm data out over into the iCloud. God bless, that's excellent. But for those of you not with the firm, you should be aware of that. And you might not want your company data living on a personal iCloud of an employee.
On that note, what are your thoughts on having Alexas or, you know, smart speakers in your office?
Don't. I'm not a fan of those devices anyway, but then I heard about a year ago that is it Amazon, I think, with Alexa, is they were recording even when they weren't being commanded to do stuff and using those recordings for training purposes. That seems like just about the most dangerous thing I can imagine sitting in to have in my office. It doesn't need to be in anybody's office, okay, unless it's like off, in which case you can find a cheaper paperweight. But if a lot of us are working from different locations, and if one room over in a quiet house is your Alexa, then I would have concerns about that. And I think it's just not a good idea to have it someplace you're working.
Encryption is a huge thing to understand and know when it might be necessary to encrypt your data. So at a bare minimum, it's important for you to understand that encryption is just scrambling the data so it can only be read by someone who has the means to return it to its original state. So there are two types of encryption. There's encryption for data that's at rest, which is data that's living on those flash drives on your desk or living on your hard drive and it's not being transmitted anywhere. You're able to encrypt that data so if someone takes your flash drive, you lose your flash drive, they can't plug it in and get all of your clients' data. There's also encryption for data that's in transit, which is just what it sounds like. It's when you send data in an email or a text. If you're attaching a lot of privileged or confidential attachments to an email, you need to be thinking, is this something that I should encrypt and do I have the means to do so? At our firm, our email system automatically is encrypting data that's being transmitted. And it's if you're the one taking on the encryption and you're encrypting a CD or you're encrypting a thumb drive, there's what's called an encryption key, which is what the person who's receiving it needs to be able to unscramble the data. And it's important that you send the encryption key in a separate means from the flash drive. You don't want to send it with a sticky note that says, here's the key, in case it ends up in the wrong hands.
And by the way, you got any problem if you need to send a flash drive full of medical records and you don't know how to encrypt it, call the help desk. They can help you with that. Absolutely.
Exactly. And one important thing to know is that encryption provides you some added protection in the event of a data breach. There are some states where theft or loss of encrypted data isn't considered a security incident or it's not considered a reportable breach. So by taking that added protection.
Sorry to interrupt, but why not? What's the logic there?
Because basically the logic is they're not going to be able to access the data. They're not going to be able to use the data. So it's essentially like it hasn't been stolen from you. So taking a little bit of protection on the front end can really pay off long term in case something goes wrong and it gets into the wrong hands. It's also important to remember that ethics opinion that we talked about earlier. It's not that the rule is that you have to encrypt every email you send, every attachment you send, but you do have to consider those factors that we listed and think about, what am I sending? Is it really overly burdensome for me to encrypt this? What are the likelihood of something going wrong? What am I actually sending? Do I need to take some extra precautions here? So it's important to just take a second, think about what you're sending, and think about if you need to encrypt it.
Yeah, and I might also add, some clients require us to encrypt all of our email between us and them. It is no big deal. We can do that. You will never notice any kind of hiccup in how fast the email is or anything like that. Again, call the help desk. Oh, I'm up. All right, backups. Backups since the dawn of computer technology have been important. We won't spend a lot of time on this, but they're absolutely critical. The firm does backups for you on firm systems, of course. For those of you outside the firm, you certainly would know, I hope, that backups are critical. They're critical today more than anything else because of ransomware. Because if you remember what ransomware is, it is that some bad guy gets credentials or somehow gets into your system, either locks up your data, turns your computer into a brick or whatever, and you can't get at your data, you can't work, right? And your systems are inoperable. Okay, well, if you've got a backup, then you can simply, after the help desk, after the IT people detach that machine from the network so it doesn't spread bad stuff, then that you can have a new computer rolled out, the backup can be taken and loaded on that computer, and you're in business and we're done. We don't even worry about paying any ransom to the ransomware thief, right? So the other thing for those of you not with the firm, well, for those with the firm, remember too, it will be a very bad day if something like that happens, or if a routine failure of a hard drive happens and you have not been doing what the firm frankly requires, which is to keep your data in iManage or in Outlook, right? And Outlook is not a place to store files, but nevertheless, don't be saving all your data on your desktop of the desktop of your laptop or desktop or whatever. Don't be doing that. If the computer crashes, it's gone. We don't back up the C drive, all right? So that's yet another reason that you need to work with the firm and follow the firm's approach in order to have the backups invoked, because things in iManage are not going away. One other thing for those of you not with the firm, the value of the cloud. The ability to use secure cloud storage has made backups, what it's done is made the failure to use backups darn near inexcusable. So you really need to think seriously where your backup is, how it's used. The cloud's a great alternative.
Okay, passwords. This is one of my favorite charts ever.
Chart.
Yeah, Jack Pringle.
We both independently found this about a week ago. It's just great. I love it.
Yes, I credit Jack Pringle in the Columbia office. I think he loves this.
Oh, that's right. I'm sorry. I'm sorry to interrupt, but that's exactly right. We didn't find it. Pringle told us about it. I'm so sorry to steal the credit from Jack. Sorry about that, Jack.
Yes. So I was a little terrified when I saw this chart because, you know, the first thing I did is I went and I looked and I saw that it would take someone about 3 weeks to hack into my password, and I thought I was doing pretty good. But that's not good, and we can do better. So it's a very basic thing that you can do. I know passwords are a pain because we're always asked to change them, and it's good password hygiene to have different passwords for everything. You don't want someone to get one password and to be able to hack into your entire life. But take a look at this chart, see where you fall. Hopefully, you know, not in the purple or the red. You want to get to the yellow and the green zones, ideally. And one tool that can really help with that is a password manager. And it's perfectly acceptable to use a password manager for a firm device or for your firm passwords. And that way it becomes more of an automized process. You don't have to worry that you're going to forget your passwords, and you also don't have to write your passwords right next to your computer so you don't forget them, which is what a lot of people do, which is not good hygiene practice for passwords either. So think of the chart and then think of this lovely underwear poster about, you know, treat your passwords like your underwear. Don't keep them on your desk. Change them. Don't share them.
Yeah, that will be the image that sticks with some people from our entire hour, just so you know. And by the way, password managers, for those of you who don't know, they're wonderful. They will generate passwords for you that are essentially unhackable. So you don't need to come up with something crazy, but so you have lots of really randomly generated passwords and then one password you have to remember. So that's the beauty of the thing. Anyway, all right, away from underwear. File sharing solutions. I don't really know how lawyers practice these days without some kind of solution to transfer big files. We have one. The one the firm uses is Sharefile. If you do not know how to use Sharefile, Shannon Mangiapane has done a lovely training session, and I believe got a notice of this just a couple of days ago, and I'm pretty sure, maybe we can confirm this, but I'm pretty sure it is now posted and available. But learn how to use Sharefile. It allows you, to be clear, to send or collect from someone a bigger file than would be easily put on email. So it's also more secure because it doesn't leave our system. Sharefile is on our systems. So even if you need to collect a bunch of documents for discovery, from a client, you can send a link, and then your client or a third party can then use that link to dump lots of big documents in a folder. That folder is on our system, never leaves our system. Ditto sending them out. So it's a really nice system. We've mentioned some others that are useful. And you need to work, if you're not with the firm, work with your tech guru to figure out one that works for you and use. Oh, by the way, I've also concluded, maybe I'm just old fashioned, but I think it's kind of rude to send somebody an email with like a, 20 megabyte attachment, because we all have limits on our mailbox size. I just think it's just sort of, it's just kind of rude. Anyway, so.
The next thing that you can do that's very simple, especially if you're an Adams and Reese attorney, is use a metadata scrubber. Adams and Reese has this built in. You see it when you are saving a PDF, or if you're sending an email, it gives you a prompt to scrub the metadata. It's very important that you don't skip that step, because the metadata can include all kinds of information about the creation of the document, the edits that went into it, who did the edits, where they were. If you're sending pictures, it can tell you the location of the picture, the time, who sent it. It can have all types of information, and some of that might be confidential, and it might not be things that can or should be shared with the other side. And it ties back into the lawyer's obligation to protect your client's confidential information. So even if you can't see it, it might be in the metadata, and you can use a metadata scrubber to very easily get that out of the document and to be able to send it without turning all that information over to the other side.
Let's talk about Wi-Fi. Where would we be today without Wi-Fi? There are two really almost theological camps on Wi-Fi. The one is that you should never use public Wi-Fi. Always use your own Wi-Fi. It's just unsafe and unhygienic to use anybody else's Wi-Fi but your own. The other is, yes, it's okay, but you got to be very, very careful, and you always need to use a VPN. More about that in a moment. My view is you should consult your tech guru, and you should join his or her theology on this. Generally, the firm's attitude is that you are set up, you are equipped to use other people's Wi-Fi if you keep your brain on alert and you don't go to Starbucks and use the one that's misspelled with the word Starbucks, right? And you always use a VPN, because we have VPNs on our devices. And if you look at the next slide, if you fall in that first hyper-paranoid camp, then what you're going to do is you're going to use the Wi-Fi hotspot on your cell phone, which can be a little pokey, but it's yours. You control it. Or you buy a separate Wi-Fi hotspot. And that's a solution. That's a good solution. If you're in the second sort of plain old paranoid camp, then just, as I said, don't be stupid about which ones you use, and always use a VPN. And your tech guru can tell you how to use a VPN. I'll just say this for right now. What's a VPN? It's a virtual private network. It is a piece of software. And every tech person for years has ever explained this to me has always used the same metaphor. So I guess it's true, which is it's like a tunnel. It's like a tunnel that goes from your device, tunnels out, goes out to our server, for example, right? And in that tunnel is where all the information it goes through, and it's safe if it's in that tunnel. So I guess that's the truth. But in any event, it protects your data in transit. And it's important for you to use that, because it is a real thing for people to be out trying to grab your signal from the air in not to pick on Starbucks, but Starbucks.
Do you have any suggestions for people that are using their Wi-Fi in their home? Is there anything that they need to consider?
Yeah, I'm glad you mentioned that, because we're all doing it, right? It's hard to give one answer for everybody, but be alert. So, for example, most of the providers will actually give you advice. So change the default password. Think about changing the name even, so it's not visible. But certainly those protections for sure. Use a VPN anyway, I think, even if you're on your home Wi-Fi. But the basic steps that your provider ought to help you walk through. Frankly, I haven't checked this with the help desk, but I'd be willing to bet you that if you had any concerns about that a call to the help desk would be very warmly received, and they would be happy to help you. Now, they're not going to know your provider and your device and all that, but those two things I know are important. One, to make damn sure it's password protected and it's a good password, okay, to get into it. And you might think about the name, because I think you can even make the name invisible essentially to somebody to your neighbor, to your mooching neighbor who wants to use it, right?
The next item here is to get a regular security assessment. This is a thorough periodic security review of the office you work in or the firm that you work for technology. And it helps you to know who has access to your data and your systems. It can help you monitor that access, see if maybe you forgot to revoke a vendor's access after you stopped using them. It also helps assess the physical security of the systems. And it may also include penetration testing, where people basically try and hack into your system and see how easy it is, or if you're well secured. So Adams and Reese does this for us, typically once a year, sometimes more often if a client requires it or if the need arises. But it's important to be aware that this is happening in the background, and that some clients are now requiring these security assessments in their contractual agreements with the firm, especially banks and financial institutions and healthcare institutions, where a lot of sensitive data is going to be transferred back and forth between them and the firm. And this has really become the standard for all big firms, is to have these annual security assessments. And the value there is really that it provides an objective outlook on the security of the network and the systems, both from the inside looking out and the outside looking in. And if you're an in-house attorney and your company is going to be having a security assessment done, it's important to know that you can raise your hand and be involved in the process. And it's important to know and review the results so you can have a voice in saying, you know, I think that we're vulnerable here, and I think that, you know, to be able to keep our company data secure, we need to pay more attention to these certain areas. So knowing that security assessments are a thing, that they're becoming the standard, it's an important piece. The next piece of the puzzle is vetting your vendors, and that includes all the cloud vendors that you're using to store all your data so you have a nice backup. The vast majority of data breaches come through vendors. This is even true for law firms. Jones Day vendor got compromised a few months ago that led to client data potentially being viewed, if not exfiltrated, from the Jones Day servers. And it didn't come through them, the hackers going after Jones Day directly, but they're able to compromise the vendors and then get in through the back door. So it's very, very, very important that you engage in your due diligence, both with the help of your tech guru, maybe a privacy data security professional, for any vendor that's involved in technology, online systems, cloud backup, or if you're giving them access to your systems in any way. I actually did a completely other hour-long presentation just on vetting your vendors, so it's a very complicated subject area. There's a lot to learn there, but it's here for our purposes of our discussion. It's just important to know that vetting your vendors, particularly anyone that's going to have direct access to your systems or your cloud vendors, is very important. You need to look at the terms of service, defining relevant terms, particularly what does it mean to your vendor when there's a security incident? What do they say is a security incident? Is it a suspected security incident? Is it only a ransomware attack? You know, getting those terms defined in a way that you're comfortable is important. It's also important to look and say, okay, let's say your vendor has some type of incident. You want it in writing that they have to tell you, and they have to tell you within a certain amount of time because your data is at risk. The terms of service will also address liability limitations, required risk reduction measures that you're going to say, if you want access to our server, you need to guarantee that you're going to be doing X, Y, and Z security measures on a regular basis. And it should also address compliance obligations in terms of meeting the federal and state requirements that may be applicable to the contract. Some other just common sense things to consider when you're involved in vetting vendors is look to the reputation of the company. Is it a well-established company that does a lot of work with law firms and understands the process? You would go for that over a mom and pop shop that maybe, you know, they don't have a lot of clients willing to give references, or they don't seem to really understand the type of data that a law firm is going to have access and have on their systems. You also want to consider the level and the scope of access that you're giving them to the confidential information. You only want to give them what's actually necessary for them to do their job for you. You don't want to give them full access if that's not necessary.
Yeah, and point to our folks, do be very aware, in case the last couple of minutes didn't convince you, do be very aware. This is actually something lawyers do now for our clients. If you hear your client, particularly one who may not be as big or sophisticated as others, are entering into a big new IT vendor relationship, flag it for them, because our privacy data can really, really help them. It is more than a thing. It's a really crucial thing for a lot of clients now, and we can bring real value there. I know Caitlin and I knew we were going to get behind, so let me, we are a little behind, so I'm just going to quickly cover a few here together, if you don't mind, Caitlin.
Sure.
Disaster recovery plan, we could spend lots of time on that. The firm has a wonderful disaster recovery plan given, you know, its location and its experience. For us, what I would say is simple. You have a June 1 or June 2 email from GIF. that you should print out and keep in several places. I have a copy in my briefcase, I have a copy in my office, I have a copy on my desk at home, and I have a copy in several places in my email and on my hard disk. It's important, save it. For those not with Adams and Reese, you know, I hope, how important a disaster recovery plan is. We've listed some things to think about. And these days, you know, where would you be without an alternative internet connection, even in your office on a pretty no flooding kind of day? So an alternative internet just for day-to-day in case the internet goes down, that's a disaster recovery plan. Anyway, that's a disaster recovery plan. Number 15, quickly, an incident response plan. This is actually something, again, that Caitlin and her people do for help clients with. You need to be able to respond when something bad happens. We have such a plan. We have some vendors on standby to help us. Again, this is not something lawyers particularly are supposed to be doing themselves, but they need to make sure it gets done. Here, this next item, number 16, probably should have been number 1. Phishing. It is the bane of our existence. The notion that so many fraudsters have taken direct advantage of scams tied to the pandemic and of the fact that people are working in unfamiliar circumstances is just one of the most reprehensible things I can think, but they are doing it, and we have to be more secure and more careful. The fact is that our firm is doing a lot in this on training. You all know that we did some testing. We emailed sort of fake phishing emails to all of us to see if we responded, and we've checked. So we're working on this really hard. Quickly, and the next slide there, one thing you need to know, and that's multi-factor authentication. Last time I talked about this, I didn't get it right. Let me see if I can get it right this time. So the way to think about multi-factor authentication for Adams and Reese, it is the Microsoft Authenticator app that's on your phone, all right? Because the way to think about this is the factors, why it's two-factor, it's something you know, something you have, something you are. So if you have something you know would be a password. Something you have would be your phone with the app on it. Something you are might be your fingerprint or your face for a iPhone, you know, Face ID thing. So if you use just one, you're less safe than if you use two. Now here's the clincher. Phishing. What are they trying to do? They're trying to get your credentials, right? They use your credentials to get into the firm systems or whatever, right? All right, let's assume they're successful. Well, if they're successful in getting access to your bank account information, right, and you've got your bank account set up to use multi-factor authentication, say a texting a number to you, a code to you, then what good is just the credential to them? The answer is not much. So multi-factor authentication is something, it is your friend, it is something you need to use where it's available, the firm already uses. And anyway, so I'll stop there. Then why don't you quickly make a nod towards client requirements there, Caitlin?
Sure. So increasingly, the clients are demanding more and more when it comes to cybersecurity, and it often comes in the form of outside counsel guidelines. This is particularly common in the financial sector and healthcare industries. And so sometimes it's built into their general, maybe their billing guidelines, and sometimes it's broken out into separate cybersecurity requirements that they require you to agree to in order to represent them. So it's really important that first you figure out if any of these are already in place for your clients, and you need to review them. But it's also important to know this going in, that these can be somewhat problematic if you don't pay attention to them. So obviously you need to know what the contents of them are. You need to be able to ensure that the law firm can actually meet the requirements that are laid out in those guidelines. And you need to make sure that some pushback is given if those guidelines maybe go beyond what the firm is capable of providing, or they go beyond what you can ethically do under the ethical rules. So here at Adams and Reese, we have a system where they're reviewed centrally through the conflicts process with input from the IT department. But one word of advice is just, if you're brought in on a new matter for a new client you haven't worked for before, ask simply, is there any cybersecurity guidelines I need to be aware of? Are there any rules I need to review? Ask the secretary who typically works with this client, and they should be able to point you in the right direction. And just read them and reach out to your tech guru if you have any questions about how to abide by them.
Next to last item, we got two more important items. We have passed, I think, now an inflection point where we really, as lawyers, need to have better communication with clients about confidentiality. So look at the examples on the slide there. Suppose a new client communicates or may communicate with their lawyer about her employment claim on a work email or work computer, or about his divorce on a home computer to which the spouse has access, or about her divorce on a family cell phone where the plan allows the other spouse to have access to messages or location. It's pretty obvious that these are a problem. And on the next slide, you'll even see there's an ABA opinion on this, that we actually have, again, minimum duty. We have an obligation to advise the client about how to maintain confidentiality. I think there's a little more to it than that, frankly. And I think it's in almost every client in every practice area, we need to make sure we and the client are on the same page as far as what's possible and what's not. And from a law firm's point of view, I mean, I think we've done better at this recently. And if you look at the next slide, this is what I have recommended to other law firms, that they need to think about this in their client intake process, that they might want to simply prohibit some forms of communication. I mean, candidly, our firm is not thrilled with communicating with clients about anything substantive by texting for a couple of reasons, but one primary one is there's no record. There's no way. I mean, I've actually gotten texts to shove them in like a round peg in a square hole into iManage, but it's hard. That's not a good place to be. And so my pitch is that we need to think seriously about how to communicate with clients in a way that's more secure, or secure to a level that's appropriate for the matter. And by the way, of course, the client is king here, right? And some clients, you might think that a particular client is being ridiculously security conscious by insisting that you, I don't know, encrypt email or whatever. Well, that's okay. You can think that, but you also need to encrypt the email. You might also have a conversation with a client about whether they want to be texting back and forth. They may love it. They may hate it. I mean, there's a part of customer service built in here too, as well as our looking out for our clients. And then the final point here is number 19. I suggest to you, and I think Caitlin joined me in this, that we all need to, all of us, us two included, we need to commit to routinely and continuously improving our tech competence. Why? Well, it's an ethical requirement, of course, but it's also that tech security is part of tech competence. And I think my experience personally is that we are more secure when we are more familiar with, knowledgeable about how to use a particular technology, whether it's Sharefile or a cell phone, right? So what I'd suggest is pick one or two topics that we talked about today and use it to learn to be safer personally in the next month. But in addition, you should resolve to continuously improve your personal basic tech competence so as to help in an underlying way increase your security competence. So learn from others within our offices, right? Lawyers and everybody else. So my secretary, Cheryl Perkins, I think I have learned more from her about using Word than, you know, any book or anybody else or anything else. Because when I don't know how to do something, I go see her and say, okay, how do you do this? And if it's really difficult, I just ask her to do it. But as often as not, I ask her to show me, well, how did you do that, right? That's what I want you to do. I want you to pick some things that you can learn how to do. So for example, how to e-file a document. It's not possible to practice bankruptcy law without being able to use Pacer. Now, is it possible to do it and have your paralegal or your secretary do all your filing? Yes, okay, I acknowledge that. But you need to know how it works. You need to know what's possible, what's not possible. And that's what you need to learn how to do. And I suggest to you, if you learn how to do it yourself, I think our collective security is going to increase as well. You need to know how to securely redact a PDF. I could give you another 5 minutes on the examples in the news, like Paul Manafort's lawyers, who put something improperly redacted in Pacer, and it then promptly dominated the news cycle as huge national news for days. You don't want to be that guy. We don't want to be that firm. how to electronically sign or edit or comment on a PDF. Again, something not hard to do. All of us should know how to do it. How to use track changes in Word. It is clearly becoming almost standard for us to do that with our clients. And not only know how to do it in, pardon the expression, a polite way, all right? Because there are ways to do it that respect the person you're working with and other ways. How to scan an OCR, a paper document, into a PDF. And what if you only have your phone? We should all know how to do that. Nobody who has a phone that was made within the last, I don't know, Caitlin, 5 years, everybody that has a phone from within the last 5 years can scan an OCR document to their office from their phone. So one of those things, some of those things, learn how to do. So with that, we have exceeded our time, but we appreciate your being with us. I think I learned a little something thanks to Caitlin, and I think you might have. It's possible. So thank you for being with us, and for Caitlin and me, we are grateful for your watching. Thanks very much.
Thank you.